Hello and welcome to Courts This Week by LiveLaw. This is Advocate Ostaka Das and I'm Debojit Das here. And as always, we're here to bring you the most important and engaging updates from the world of courts and law in India. This week was heavy with stories that cut across personal liberty, constitutional economics, sensitive social debates, and even Bollywood. So let's get into it. So the Supreme Court has finally issued notice in the Delhi riots' larger conspiracy case. Umar Khalid, Sharjeel Imam, Miran Haider, and Gulfisha Fatima, all of them have been in jail for over 5 years now under UAPA. And now their bail pleas will be heard on October 27th. Kapil Sibal even said in court before Diwali so that they can be out by Diwali.
The big point of criticism here is that these accused have been in jail for 5 years now and still haven't faced trial. All of it traces back to FIR 59 of 2020, which alleges that they were part of a larger conspiracy behind the Delhi riots of February 2020, which was set against the backdrop of the CAA-NRC protests. We've discussed this in previous episodes, but the reason why they've not been released on bail yet is that our anti-terror law UAPA is added to the mix, Section 43D5 in particular, which makes bail almost impossible if the court thinks there's even a prima facie case. That's the brick wall they keep hitting.
Isn't the process itself becoming the punishment then?
That's what the Supreme Court at least has said in a lot of these cases. We always say innocent until proven guilty, but in UAPA cases like this, it often feels the other way around.
Moving on to former Chief Justice of India, D.Y. Chandrachud, who has set off quite a storm with his remarks on Ayodhya. In an interview with News Laundry, he said the very construction of the Babri Masjid was a fundamental act of desecration. Basically, he was suggesting that the wrong did not begin in 1949 with the idols being placed inside or in 1992 with the demolition, but way earlier with the mosque's erection itself. Now, this stands out because, remember, he was part of the unanimous 2019 Supreme Court bench that actually decided the Ayodhya land title case. So, Ostaka, why is this comment seen to be so controversial?
Well, the key point is, in 2019, the court never said that the mosque was built by demolishing a temple. What the bench actually did was examine the Archaeological Survey of India's report, and that report suggested that there was a 12th century structure of Hindu origin beneath the Babri Masjid.
So, did the Supreme Court actually accept this report?
It said that the ASI report would have to be read contextually and with caveats. Because while the ASI did find traces of this older structure under the mosque, it never said how or why that structure was destroyed, whether it was actually demolished to make way for the mosque, or whether its remnants were even reused in the mosque's construction. And since there's a 400-year gap between the earlier structure and the Babri Masjid, with no evidence about what happened in between, the court said that the report had to be read with caution. And that is why the court refused to base any findings on title on these archaeological conclusions. What set off the debate now is that Justice Chandrachud's recent remarks are being seen by many as at odds with the 2019 judgment itself.
Moving on to aviation, the Supreme Court has been pulled into the fallout from the Air India flight crash that killed 260 people in June. An NGO, Safety Matters Foundation, has asked the court for a court-monitored independent probe, arguing the official inquiry is compromised. They say the regulator, the DGCA, is too involved in the investigation team. So, what does the court has flagged here, Ostaka?
So on Monday, the Supreme Court flagged concerns about how parts of the preliminary crash report issued by the Aircraft Accident Investigation Bureau in July of this year was selectively leaked to the media, fueling a narrative that the pilots were to blame. So the petitioners have argued in this case that the preliminary report suggested the crash happened because the fuel cutoff switches were moved from run to cutoff, effectively pointing to pilot error.
So they worry that the investigation was being rushed to blame the crew.
Exactly. The petitioners contend that the preliminary report was issued hastily and that leaking selective findings to the media created a prejudicial narrative. Worse, 3 members of the panel are DGCA officers, and the DGCA itself is under scrutiny for regulatory lapses. Anyway, for now, the court has called the leaks unfortunate, stressed that confidentiality must be maintained until the inquiry is complete, and has now sought the respondents' reply on whether an independent probe by an expert body is needed.
From aviation to Bollywood, Jacqueline Fernandez moved the Supreme Court seeking quashing of a 200 crore PMLA case tied to alleged conman Sukesh Chandrasekhar. The ED says she received lavish gifts, jewelry, cars, even a yacht reportedly called Lady Jacqueline, bought with the proceeds of the crime. Fernandez says she was duped, had no knowledge of the money, it was tainted, and is herself a victim here. The Delhi High Court refused to quash earlier holding that knowledge is a matter for trial. How did the Supreme Court take this, Ostika?
In the Supreme Court, senior advocate Mukul Rohatgi argued that Fernandez cannot be dragged into trial without evidence of intent. He stressed that under Section 3 of the PMLA, there has to be knowing involvement with proceeds of crime. She simply accepted gifts without knowledge that they came from extortion. He even pointed out that in the extortion case under Mokoka, Fernandez is actually a prosecution witness, so treating her as an accused in the PMLA case makes little sense.
That actually sounds like a strong defense. So did the court actually accept it?
It did not. The bench led by Justice Dipankar Datta said that in terms of the Vijay Madan Lal Chaudhary judgment, the law casts a very wide net. Even close association with someone accused of laundering money and accepting benefits can attract liability at this stage. However, Fernandez will be able to raise all these defenses in the course of trial.
In corporate law, the Supreme Court has finally closed the chapter on the Bhushan Power and Steel insolvency. It upheld JSW Steel's 19,700 crore resolution plan, reversing an earlier order that had pushed the company towards liquidation. The court said reopening a plan after it's been approved by the creditors and the tribunals and even partly implemented would shake investor confidence in India's insolvency framework. But Ostika, can you walk us through the background here a little?
Sure. So, Bhushan Power and Steel was once a debt-ridden company, one of the largest insolvencies under the IBC. So, in 2019, creditors approved JSW Steel's bid to take it over. Since then, JSW has invested thousands of crores, modernized the plants, and kept the company running. But in May this year, a two-judge bench of the Supreme Court unexpectedly set aside that plan and ordered liquidation, saying JSW hadn't met timelines and had misrepresented facts. That order shocked the insolvency world. JSW and the creditors quickly sought a review, and the case was reheard by a larger bench led by Chief Justice B.R. Gavai. This time, the court took a very different view. It said delays were largely due to regulatory hurdles like money laundering proceedings, not JSW's fault. More importantly, it stressed that the commercial wisdom of the creditors should prevail, and once a plan is implemented, it can't be unraveled years later. In the end, the court upheld JSW's resolution plan, noting that it had already turned a loss-making entity into a profitable one.
The Supreme Court this week dismissed a public interest litigation seeking a ban on Salman Rushdie's The Satanic Verses. The petitioners called the book blasphemous, pointing to the passages on Prophet Muhammad and Hindu deities. But when pressed, they could not show any valid notification banning the book. Without that, the court said there was simply nothing to adjudicate.
Exactly. The bench of Justices Vikram Nath and Sandeep Mehta noted that there is no live ban notification today. In fact, last year, the Delhi High Court had already asked the government to produce the original 1988 order supposedly banning the book, but when it couldn't, the court treated the ban as lifted. The Supreme Court has now declined to revisit that.
But don't you think that this also ties into a bigger debate how India deals with the free speech and religion? Take 299 of BNS, for example, earlier 295 of the IPC, which criminalizes deliberate and malicious insults to religion. We've had complaints over the years that this provision is being used against writers, artists, comedians, and even cricketers for some reason.
You're right, Debujit. And if you remember, just this July, the Punjab government went a step further, introducing a bill that would make sacrilege of texts like the Guru Granth Sahib, Quran, Bible or Gita punishable with life imprisonment. For now, that bill has been sent to a select committee. But the constitutional position is clear. Article 19(2) allows speech to be restricted only on narrow grounds like sovereignty, security, public order, decency, and courts have usually insisted that these limits are to be read very strictly. As Justice G.S. Patel memorably said in the Kunal Kamra case, free speech should always be under-regulated and it's the restrictions on it that must be over-regulated. The bottom line, in our system, freedom is meant to be the default and any attempt to curb it has to be handled with extreme care and caution.
On trial procedure, the Supreme Court has sounded the alarm on delays, especially in sensitive cases. A bench of Justices J.B. Partiwala and K.V. Vishwanathan said the old practice of day-to-day hearings has virtually disappeared, replaced by adjournments that stretch cases out for years. That, the court warned, weakens the evidence, risks witness tampering, and undermines justice. The question now is, how do we fix it?
Well, the court thinks the answer lies in reviving continuous trials. It has asked every high court to form committees to work out how this can be implemented again. The judges pointed out that 3 decades ago, day-to-day hearings were the norm. And in fact, Section 309 of the CRPC, which is now Section 346 of the BNSS, already requires it. The logic is simple. Piecemeal trials cost more than they save, and that they also erode confidence in the system. The court even laid down clear directions like no adjournments if witnesses are present except for genuine emergencies, and costs or even bail cancellation if delays are engineered by the defense.
These are actually very important directions, Ostika, but can you tell us a little more about the factual backdrop of this case?
The backdrop was a CBI case arising out of West Bengal post-poll violence. In that matter, the victim had begun testifying, but her cross-examination was pushed off for nearly 4 months. The Supreme Court flagged that such adjournments could unwittingly aid the accused and stepped in, directing the trial court to complete the victim's evidence without delay and finish the case by the end of this year.
Next, we have a federalism case on taxation. The Supreme Court struck down a Rajasthan notification that exempted asbestos sheets made within the state from value-added tax, while taxing identical sheets brought from outside. A bench of Justices B.V. Nagaratna and K.V. Vishwanathan said this violated Articles 301 and 304A of the Constitution, which guarantees free trade across India. In other words, states cannot tilt the playing field to protect local industries by using taxation as a weapon.
So in this case, the court's reasoning really gets to the heart of economic federalism. Article 304A allows states to tax goods imported from other states, but only if the same tax applies equally to local goods. Here, Rajasthan gave a blanket exemption to its own manufacturers, creating a fiscal barrier against outsiders, and that's what the court called discriminatory. The judges even said that the outcome might have been different if the exemption was linked to using fly ash sourced from Rajasthan. That would have tied the benefit to a local resource, not the place of manufacture.
So, the larger principle is that taxation cannot be used in a protectionist, hostile way.
Exactly. The court leaned on earlier precedents like Jindal Stainless and Sri Mahavir Oil Mills to stress that only exemptions serving a valid, limited, non-protectionist purpose like helping backward regions can survive. Otherwise, equal tax burdens must apply whether the product is made in Jaipur or Jharkhand.
Now let's move on to some news from the Delhi High Court. The Delhi High Court this week heard a defamation suit with implications for streaming platforms. IRS officer Sameer Wankhede, known for his role in high-profile drug cases, has sued Netflix, Red Chillies Entertainment and others over the series Bads of Bollywood. He says a character is clearly modeled on him and tarnishes his reputation. But Justice Purushendra Kumar Kaurav pointed out a basic hurdle. The plaint does not explain why Delhi courts have jurisdiction under Section 9 of the CPC. Some reports even suggested the suit was rejected. So what really happened here?
So in plain terms, the court said unless Wankhede can show how the cause of action arises in Delhi, the suit can't really stand here. And what's cause of action? It's simply the reason for filing a case and also why it's being filed in a particular court. For example, if a newspaper in Delhi publishes something defamatory about you, you'd like to go to a Delhi court because that's where the harm occurred. But with OTT platforms streaming everywhere and social media being everywhere, territorial jurisdiction gets blurry. That's why we've seen a spate of personality rights suits like we discussed last week of Amitabh Bachchan, Anil Kapoor and even Karan Johar filed in the Delhi High Court. Coming back to Wankhede's case, his lawyer, senior advocate Sandeep Sethi, argued that since the show streams in Delhi and memes about him circulate here, that should give Delhi jurisdiction.
So, did the bench agree with this?
Not quite. Justice Kaurav said that the plaint hadn't made this clear and even remarked, I am rejecting your plaint. But on Sethi's request, the court allowed time to amend the pleadings. So the suit hasn't been thrown out, it's just on hold until Wankhede's lawyers can fix the maintainability issues.
And finally, a socially resonant case from the Delhi High Court where a woman has sued her husband and his alleged lover, claiming the lover's interference destroyed her marriage. The defendants argued that only a family court could hear this, not a civil court. But Justice Purushendra Kumar Kaurav disagreed, saying that if wrongful conduct and causation are properly pleaded, a civil action for alienation of affection is indeed maintainable. Ostika, can you walk us through why this matters?
So this is relatively new territory for Indian courts, which is why this case is quite significant. Alienation of affection is what's known as a tort, a civil wrong where you can claim damages if someone's deliberate actions cause you harm.
Right.
Here it's specifically a hard-barm tort borrowed from Anglo-American law. In plain terms, it lets a spouse sue a third party, usually the lover, for intentionally interfering in a marriage. But it's not easy to prove. You have to show deliberate acts aimed at pulling a spouse away, that this conduct directly led to the loss of companionship, and that damages can be quantified. This is a big development. I cannot think of any other purely AOA damage claim until now. And the Delhi High Court itself noted in its judgment that the concept remains judicially acknowledged but not formally adopted.
And what about the Joseph Shine ruling? That has to be, come into play here.
Great point. The husband here, who has been accused of adultery, leaned heavily on Joseph Shine, which decriminalized adultery, and he argued that adultery can't have legal consequences anymore. By the way, both the husband and the affair partner have been sued by the wife here. Anyway, on Joseph Shine, the High Court said it only affirmed that the state has no role in criminalizing the private and intimate choices of individuals. Right. But it did not create a blanket license to maintain extramarital relationships without any consequences. That said, the court has not decided the case on merits yet. It has only said that the plaint discloses a prima facie civil cause of action for alienation of affection, and summons have been issued. The actual fate of the claim will be decided later during trial.
That wraps up this week's expanded edition of Courts This Week. From bail pleas under UAPA to judicial calls for speedier trials, from corporate insolvency clarity to debates on personal rights and marriage, the courts were busy shaping the law in multiple directions. For full coverage of these stories and more, visit www.livelaw.in. Until next time, thank you for watching.